Chief Justice, again, thank you for having us. Before we actually launch into it, a few housekeeping matters. This segment, which is our fourth with you, will be broken into three parts. So Dennis will start, then I will follow, and President Saunders will close. In response to your feedback, we have put aside 30 minutes at the end dedicated to discussion. So we have a longer and merely actually more extended period of discussion with you. In light of that, what we're going to ask is that as we go through the parts, the three parts, please post any questions you may have in the chat that we all have access to, and we will come to those questions in the dedicated 30-minute period. Of course, if there are things that arise as we go along, you may use the raise hand feature, and we will try and address those in the course of the flow. So to start us off is Sir Dennis Byron, and I'm going to pass you on to Sir Dennis. And what we're really talking about today is case and case flow management, and looking at it in three parts, beginning with Sir Dennis.
In this respect, before Sir Dennis comes on, I noticed, Sir Brian, you had said parts 28 and 34, but I think the parts that we are going to address particularly would relate to parts 25, 6, and 7, case management, sanctions, that sort of thing.
Yes. I stand corrected, President Saunders. Thank you very much.
Yes.
Okay. Well, thank you very much. We get into it straight away. I'm very happy to be here once again. And as we move forward, I'll be, as President Saunders indicated, Adrian has instructed me to call him, indicated that we'll be dealing more specifically with parts 25 and 26. Now, as usual,
So Dennis, sorry to interrupt you. Can you just adjust your camera? We're seeing your tie. Can you just adjust?
Oh, sorry.
No, that's fine. It's a nice tie, so that was good. But
thank you. Yeah. Can you see it better now?
Yes, that's perfect. Thank you.
All right. Our objectives today. Let's see, I'm not seeing your slides, Andy. Yes. Yeah, our objectives today relate case management to the overriding objective, the role of the judge to actively manage cases, ensuring the just and proportionate disposition of disputes, and learn the principles and techniques of active case management. Understand the system of ensuring compliance with rules, directions, and orders. The relevant overriding objective is part 1.1. The overriding objective is to enable the court to deal with cases justly at proportionate cost. And that involves ensuring the parties are on an equal footing, saving expense, applying the principle of proportionality, making sure that the hearings are expeditious and fair, that there's a rational use of resources, and ensuring obedience to court rules and orders. Now, part 25.1 states that the court must further the overriding objective by actively managing cases. So we look first of all at the role of the judge, the case management judge, who must become responsible for the just and proportionate resolution of disputes by actively managing the conduct of the cases that are before the court. Now, this means that the judge has to assume the role of leadership and management. But we make the point that the most effective way that judicial power should never be abused when applying the overriding objective. And the next slide shows you that the quality of a judge in applying the overriding objective implies humility. Humility is strong and arrogance is weak. So in a nutshell, these are some of the qualities we expect that the application of the CPR will evoke. Now, as you go through the rules, overriding objective and related rules, you will notice that they all relate to the overriding objective in one way or other. So on these two slides, as I look at the duties of case management, which are set out in part 25.1, I related the various rules to values of the overriding objective. Now, this is the only part I've done it to, but I would invite you as we go through the rest of the program to yourself make an assessment of the actual overriding objective, which is given implementation by the specific rules. So now here we have that ensuring that parties are on an equal footing. The rules require that the judge must ensure that no party gains an unfair advantage by the failure to give full disclosure. You save expense by encouraging settlement on fair terms and encouraging parties to use ADR, including mediation. You deal with cases proportionate to the amount of money involved, the importance of the case, and the complexity of issues. And you do that by deciding promptly which issues need full investigation and trial, and disposing summarily of the others. You consider the financial position of each party, and you consider whether taking a particular step will justify the cost of taking it. You ensure that matters are dealt with expeditiously and fairly by identifying issues at an early age, dealing with as many aspects of the case on the same occasion as is practicable, and deciding the order in which issues are to be resolved. Allotting to each case the appropriate share of the court's resources while taking into account the need to allot resources to other cases. And you deal with as many aspects of the case as appears appropriate to do without requiring the parties to attend court. You make use of technology. You enforce compliance with rules and practice directions and orders. And you give directions to ensure that the trial of the case proceeds quickly and efficiently. So these are the principles of case management, which are in fact laid out quite specifically in part 25.1. Now, the powers of management, and again, I suggest that these reflect the overriding objective. You have your power to adjourn, to extend or shorten the time of compliance of matters, stay the whole or part of proceedings, and you can transfer matters to another court in the Bahamas. You can decide which orders, with the order in which case matters are to be tried. You can direct a separate trial of any issue. You can direct the hearing of part of proceedings are dealt with as a separate proceeding. You can try 2 or more claims at the same time. You can dismiss or give judgment after trial on preliminary issues. And you can exclude an issue if it's not required to do substantial justice. Now, you'll have noticed that some of these issues have been discussed in other aspects, and you'll notice that will be a fair amount of overlapping and repetition. Now, you also have the power to direct that evidence be given in written form. You can hold a hearing or receive evidence by telephone or other method of direct oral communication. You can require the maker of an affidavit to attend and be cross-examined. You can direct that notice of any proceeding be given to any person. And you can require a party or attorney to attend court. where two or more parties are represented by the same attorney, you can give consequential directions. Where there's substantial financial equality, you can order the party applying for an order to pay the other party's costs for compliance. And you can take any other step, give any other direction, or make any other order for the purpose of managing the case and furthering the overriding objective, including, and I want this just be just en passant, but emphasize, including an early neutral evaluation or directing that such a hearing take place before a court-appointed neutral third party with the aim of helping the parties settle the issue, the case. Now, I think we have already discussed what an early neutral evaluation is. But if not, we will address it before the end of the proceedings. Now, the court has power to impose condition when it gives an order or makes a direction. And it could require a party to give an undertaking, to give security, to pay all or part of the cost of proceedings, to pay money into court, to permit entry to property owned or occupied by that party. And in considering whether to make an order, the court may consider whether a party is prepared to give an undertaking. In special circumstances, on the application of a party, the court may dispense with compliance with any of these rules. Now, the court can make orders on its own initiative. And this is one of the culture changes that the new CPR brings in, that you don't have to wait until an application is made to do something which is necessary or desirable. When the court proposes to exercise its powers on its own initiative, however, it must give any party likely to be affected a reasonable opportunity to make representations in oral, in writing, orally, telephonically, or by other means. And if the court proposes to conduct a hearing in the matter, it's required to give the other party, the parties involved, 7 days notice. Now, you notice that one of the elements of the overriding objective, part 1.12F, requires the enforcing of compliance with rules and orders. And one of the important sanctions is the striking out of the statement of case. And the court may do that in whole or in part if a party fails to comply with the rule, direction, or order. Now, this is a very important sanction, and it should ensure that parties pay attention to complying with the rules and orders made by the court. If the statement of case does not disclose any reasonable ground for bringing or defending the claim, or is frivolous, vexatious, scandalous, an abuse of the process of the court, or is likely to obstruct the just disposal of proceedings, or its products, or it does not comply with the requirement to give adequate particulars, the matter can be struck out in whole or in part. Now, where a claimant's statement of case is struck out with an order to pay costs, and before those costs are paid, the claimant starts a similar claim against the same defendant, the court may, on application, stay the subsequent claim until the costs are paid. Now, striking out when no sanction is imposed Now, and it's important to note the difference of striking out where it's required or prescribed by the rules, as in Rule 26.3, where it dealt with the way in which the statements of case were presented to the court. But if a party has failed to comply with a rule or a court order, in respect of which no sanction has been imposed, a party may apply for an unless order with or without notice, once it is accompanied by an affidavit and with the facts specified in this rule. And the court may grant the order, or direct a hearing, or seek the views of the other party in deciding how or whether to make the unless order. The unless order, if made, must identify the breach and require the party in default to remedy the breach by a specified date and to pay assessed costs. If the default is not remedied by a specified date, the statement of case shall be struck out, and you notice shall. But a party can apply to set aside any order made without notice under Part 11.16 of the rules. Now, if a party does not comply with an unless order, any other party may apply for judgment and costs to be assessed by making a request, which is accompanied by a certificate that there was a right to enter judgment because of the non-compliance, with proof of service of the unless order, and the statement of case showing the entitlement to judgment. Now, judgment for a claimant in relation to money or delivery of goods, where there's an alternate claim for the value of the goods, must be in accordance with the statement of claim plus interest. And in any other case, for the judgment that the court considers to be appropriate. And a judgment for a defendant must be for assessed costs. Now, the rules are not draconian. It affords power to set aside a judgment after striking out, if the right to enter judgment had not arisen. In such a case, there's no discretion. The court must set aside the judgment. But if the application is to set aside is based on any other reason, the provisions of the relief from sanctions rule, which we are going to come to in just a minute, would apply. Now, those rules put certain duties, I think, of management on the court and on the parties before the court. Because it becomes a key requirement that if the court makes an order or gives directions, it must, whenever practicable, specify the consequences of the failure to comply. Now, where there is a default, any express sanction for non-compliance has effect, unless the party in default obtains relief from sanctions, which we will discuss shortly in the next slide. But where a rule or direction requires a party to do something by a specified date with specific consequences for failure to comply, the time for performance cannot be extended by agreement between the parties. But on the other hand, if the consequences are not specified, the time may be extended by agreement, so long as the date of hearing or trial is not effective. If consequences are specified, the need for unless orders do not arise. So the management of the case is enhanced if the court specifies the consequences of failure to comply when it makes any order or gives any direction. Now, this is a very important rule, relief from sanctions. Because, again, the overriding objective is to arrive at just and proportionate dispute resolution. So that if a party is liable to a sanction, it may apply for relief. And the court will consider all the circumstances so as to enable it to deal justly with the application, including the need for litigation to be conducted efficiently and at proportionate costs, and to enforce compliance with rules, practice, directions, and orders. An application for relief must be supported by evidence. And the court may not order the respondent to pay the applicant's costs unless exceptional circumstances are shown. Now, as simply as these rules are written, they are most likely to give rise to judicial interpretation. But the rules make it clear from the nature of the matters that the court is required to consider that you can't assume that relief from sanctions will be granted, because the court has to balance whatever excuse or reason is advanced. The court has to balance that against the need for litigation to be conducted efficiently and at an appropriate cost, and the requirement to ensure that rules and orders are complied with. Now, the court can rectify matters where the consequences of non-compliance are not specified. So again, this is another reason why the court must take care when it's making an order. But this means, however, that if there's a procedural error or a failure to comply with a rule, direction, or an order, there's not an inevitable invalidation of a step taken, unless the court makes an order that that is the case. So where there's such an error, the court may make an order to put matters right. And it may make an order with or without an application by a party.
Chief, just letting you know that we are in the halfway mark.
Beautiful, thank you very much. Now, another aspect of case management, as we've said earlier, has to do with the issue of early disposition of matters, which do not require full hearing. And so in addition to the general powers the court has, Part 15 of the rules deals specifically with summary judgment, which allows the court to give judgment without a trial if it considers that the claimant has no real prospect of succeeding, or the defendant has no real prospect of successfully defending the claim. And I draw an example, for example. If a statement of case for the claimant has been struck out, then the claimant will have no prospect of succeeding. If a statement of defense has been struck out, the defendant will have no prospect of successfully defending the claim. Those are two obvious reasons where you can get summary judgment. But of course, there are other reasons, other circumstances as well. But you must read Part 15.3 to discover the exceptional types of proceedings for which this process is not available. Now, a notice of application must identify the issues the court should deal with. And significantly, the court could exercise its powers with regard to summary judgment without notice at a case management conference. The application must be supported by affidavit evidence, and they must be served this on the other parties, any of whom may file and serve affidavit evidence. Judgment may be given on any issue of fact or law, whether or not the judgment will bring the proceedings to an end. Where proceedings are not brought to an end, the hearing must be treated as a case management conference. Now, one of the important issues is minimizing with interlocutory hearings. Now, every time we have been looking at the issue of backlog reduction and increasing the time to disposition, and we have gone into a court office, I have found several files where the matter has come before the judge on several occasions. So files that are in the court system for 3, 4, 5, 6, 7, 8 years may have come before the judge 30, 40, 50 times. Now, multiple interlocutory hearings offend aspects of the overriding objective. Cost and delay are likely to be reduced if there are as few interlocutory hearings as are necessary for the just disposition of the matter. An imperative of case management strategy is to eliminate or minimize these hearings by determining which issues, by determining such issues on the paper whenever possible. The court expects and encourages parties to confer in good faith, to resolve interlocutory disputes without the need for intervention by the court. Of course, there's an exception to this in relation to those applications for narrowing the issues or hastening the resolution of the case. For example, striking out applications or applications for summary judgment. Now, and this really, as you know, the duty is basically on the court, but the litigants are required to assist the court. So there should be every effort to address all matters that are required for the just disposition of the case at the first case management conference or as soon after that as possible. And this could be facilitated by the court developing a questionnaire which interrogates all the relevant issues and encourages the parties to confer with each other before responding, with a view to agreeing answers where possible. Now, this will be discussed in some detail later on in the session. So it's sufficient for me to say that as a result of this approach, that is using the questionnaire technique, the court could give directions for narrowing issues, disclosure, filing of witness statements, managing alternative dispute resolution mediation, and also setting all of these matters in accordance with agreed time schedules. Now, later on when we discuss performance standards, I'll be suggesting that the court should aim to limit the number of interlocutory proceedings before disposition. Now, we have discussed before an important issue of early identification and trial of preliminary issues. And I just wanted to highlight that in this session, because that could be an important element of case management strategy. But one has to highlight that the purpose of doing this is to further the overriding objective by saving time and expense. So, what type of matters are eligible for hearing as a preliminary issue? And there has been some jurisprudence on this. There's a famous quotation from Lord Hope in the case of Boyle against SGA, the United Kingdom House of Lords. We posited that the test would be if there was a knockabout point, which is an issue, which if determined would likely prove decisive to the reference. But it's very essential to remember both the court and the litigants and the attorneys that care needs to be taken, because vaguely drafted questions for preliminary determination or questions that have no significant impact on the outcome of the case can lead to disproportionate outlay of costs early in the proceedings. And so one has to avoid what Lord Scammon described as the treacherous shortcut. Now, when the court is exercising its discretion, and it has to take care on these issues, there should be little room for appeals in the exercise of the judge's discretion because of the wide latitude afforded to trial judges, so that the appeals would more or less be limited to a failure to apply correct principles in the exercise of the work of the court. And generally, because these types of orders are fact-specific, it's not usual that one would find precedent to govern the specific facts of the case that you have in mind. Now, how do you determine, therefore, whether there should be such a hearing? And this is exercised the mind, and in fact, one of the leading answers to that question is to apply what is called the 10 questions developed by Justice Neuberger, as he was at the time, in the case of Steele and Steele. Now, these 10 questions were summarized into 4 questions by Justice David Steele in McLaughlin and Jones, and I give the reference to that as well. And this is what I just want to address these for, because I think this largely summarizes the 10 questions of Justice Neuberger. Only issues which are decisive or potentially decisive should be identified. The question should usually be a question of law. They should be discussed on the basis of a schedule of agreed or assumed facts. And they should be triable without significant delay, making full allowance for the implications of a possible appeal. Now, I set out here Justice Neuberger's 10 questions, which I don't need to go through because the slides will be with you and you can study them at your pleasure. So we move on to the next slide. We have discussed evidence management before, but I close out my session with a general reminder about the overriding objective as it relates to evidence management. Ambush is abolished. The case management conferences allows the court to ensure openness and transparency that are necessary for a just and proportionate resolution of disputes by making orders with timetables for disclosure, for the filing of witness statements, for managing expert evidence, and promoting efficiency, saving time, and even supporting settlements. The court can also direct how evidence will be adduced during trials. Directing that witness statements could be evidence in chief, a major time-saving procedure. Managing cross-examination to allow only what is necessary for resolution of disputes. Larissa, I've now stopped in time for questions before running out of my time schedule. All of course, as Peter had suggested, we are encouraging you as far as possible to put your questions in the chat box, because in the feedback that we've got from our proceedings, several persons requested that we allocate more time for discussion at the end of the proceedings. So if there's any pressing question, I can take it now. If not, you can put it in the chat and we'll discuss it together with other questions at the end of our session, or before the end of our session. Thank you.
Okay, I'm not seeing anything in the chat, so I'm assuming that everyone wants to keep the powder dry until perhaps we complete the presentation. Justice Jamadar will continue with the next part of the presentation. Peter, are you with us?
Yeah, I'm here.
Okay.
Great. So thank you very much, Sir Dennis. And what we hope you're beginning to realize and see now as we drill down a little deeper is in our first introductory session, when we shared with you, we spoke about, projectizing a case, treating a case as a project. And we hope that you're beginning to realize that what the rules provide are principles, values, but also very practical tools that allow for effectiveness and efficiency in dealing with a case. And of course, case and case flow management are at the heart, at the center of how we deal effectively and efficiently with the case. Notice we speak about case and case flow, and we do that very deliberately because it's not just the management of a single case, it's the management of all cases and the management of your docket, and therefore it's also the management of how a case flows from beginning, inception, to disposition, end. I'm going to spend a little time with you. I think I have about 13 minutes, and I'm going to chat with you about the use of questionnaires, the importance of parties being present at hearings, talk to you about timely decision makings, especially a little focus on the use of templates for opinions, and then finally just spend a little time chatting about the use of checklists by judges, all as tools that can help in case and case flow management. The objectives therefore of this session, Larissa, are to relate the court's powers of active case management to, as I said, the use of questionnaires, the importance of parties' presence at hearings, timely decision-making, and the use of checklists. And also to understand how oral decisions and the use of templates for opinions improve efficiency and effectiveness. So let's see how we can cover this material. Questionnaires. Well, and you will begin to see that there's a lot of overlap and repetition, and that's very necessary because there are central principles and values running through these rules. Coming back to them again and again, we hope will help you remember what they are and also see how they apply in different areas. So the purpose of case and case flow management, part 25.1, you've heard this over and over. It's to actively manage cases, and there you see some of what is involved. You identify and prioritize issues, something you've heard already, encourage settlement, use ADR, dispose of as many issues as you can on the same occasion, and even without parties being present, encourage parties to cooperate on all aspects of the case, fix timetables, give directions, and ensure efficiency and timeliness. And in doing all of this, the rules say active case management must make effective use of technology. How does that relate to questionnaires? Well, can you use questionnaires? The answer is yes, you can. Have you included questionnaires in your rules? Not on our perusal of the rules. So why should we be chatting with this subject with you this afternoon? Because we think questionnaires are critical. They are very useful, but they are invaluable for, as I said, I've been saying over and over, effective and efficient case flow management. You should know that several Caribbean jurisdictions have made use of questionnaires as an aid. And for example, part 27.9 of the ECSC rules and part 27.10 of the Trinidad and Tobago rules. Those are just examples. However, even without specific rules, questionnaires can be developed and used, whether institutionally, which we recommend as a preferred course, but even if not so, individually by every judge. Why? Because under 26.1 of your own rules, 26.12V says that as a judge, as a court, you can take any step, give any direction, or make any order for the purpose of managing the case and furthering the overriding objective. That is to say, even if institutionally questionnaires are not made a part of your rules, we recommend that they should be. An individual judge in the management of any case can use questionnaires. So you can do it. As we move along, what's the value? Well, by now you should have realized that what makes these rules different is the recognition that knowledge is power. Information is the key. And the earlier you have relevant information, the better you can manage a case. So what is the value of questionnaires? Four values that I'm going to share this afternoon. First and foremost, you can gather as much relevant information, and you can gather it as early as possible to enable this case flow management and case management we're chatting about. Secondly, the use of questionnaires can facilitate early disclosure and agreement among parties and attorneys. If the information comes forward early, documents, facts, there's a much greater chance that there can be agreement, because sometimes these documents cannot be contested. Therefore, third value, the use of questionnaires and the eliciting of information, relevant information as early as possible, can support cooperation and therefore settlement. Finally, the fourth value that I would share is it can enable early, effective, efficient, and timely timetabling and disposition of applications, issues, and of course, events that occur along the life cycle of a case. A case has a single life cycle with many events along the way. So those are at least four reasons, four values for the use of questionnaires. As we move along, when should you use questionnaires? Well, there are three possibilities. We recommend highly prior to the first CMC. That is to say, the court office, you institutionalize this, and the court office sends out with the claimant's originating bundle of documents a standard questionnaire form. And that questionnaire must be filled out and returned with your appearance and or other documents that a defendant may have to file. Alternatively, it can be issued the first CMC or first court hearing, depending on how you commence proceedings. As we looked at when last we met with you, you saw that there are 3 ways of commencing proceedings. So whichever one it is, at the first CMC or the first court hearing, that is when an order can be made. But if you are going to make an order for questionnaires, then for the use of questionnaires, then they must be made with clear time-based directions on or before a certain date and with consequences for default. We saw earlier that there is a recommendation in the rules that whenever an order is made, consequences should be attached. Questionnaires can also be used. This is on timing. When can you use them? Can also be used prior to pretrial review. And they can be very helpful here, so that before you come to your pretrial review, which is the intention of which is to say, well, are you ready for trial? That's a pretrial review. You send out a questionnaire, or questionnaire is required to be filed, say 7 days or 5 days before the pretrial review. And what do you do with that? We'll come to that in a little while. But basically, you want to make sure that you get all the information to ensure that at the pretrial review, you can proceed with the matter, or you can know what are going to be some of the issues that may arise, because trial date certainty, remember the life cycle, trial date certainty is a big aspect of these cases. I think Sir Dennis told us when last we met that one of the things that is just not done is an adjournment of a trial, or sorry, President Saunders. So those are the 3 opportunities as to when you can use questionnaires. Moving along, what do you put in a questionnaire? Well, of course, you ask what information is required to actively and effectively manage case and case flows. That's the information you want to gather. So as a general principle, that's what you want to get. If it's before a CMC, I'm not going to go into detail. We've covered this. So Dennis has just covered some of this. Look at part 25.1, the objectives of case management. Whatever those objectives are, you want the information that will help you fulfill those objectives. Also consider part 27.5, the orders that you can make. Because if you have to make certain orders at a CMC, well, then you need to find out what is the information I need to make those orders. An easy example is, say, disclosure. Well, in a questionnaire, you can ask, have you disclosed all the documents? Are there any other documents? What are those documents? So that when you come to a CMC, you have all of the relevant information. Are there any preliminary issues that you intend to raise? All of these are questions that can be asked in advance. You remember the very last slide, or was it the second to last slide? I think it was the last slide of Sir Dennis, spoke about trial by ambush. Questionnaires can reduce not just trial by ambush, but eliminate ambush for judges and parties at every hearing along the life cycle. So that's the point of the questionnaires. If you use it prior to trial at the pretrial review, I just went through this, but then of course you want to consider all orders and directions made in the proceedings that need to be followed up and complied with so that the trial can proceed efficiently, and your questionnaires will be aimed at gathering the relevant information. At the very end of what I'm going to do with you, I'll talk to you about checklists. And when you think about checklists, your questionnaires want to support your checklists also. So what's an example of a questionnaire? Well, part 27.10 of the Trinidad and Tobago rules has referred to therein a form 9. Let's just see if this is going to open up. Larissa, by the way, Larissa, the legal officer of the CAJO, is assisting us. Yeah, sometimes it doesn't open, Larissa. So if it doesn't open, it's okay. I think that we've had that difficulty before. So let's just keep going. I can do it if it doesn't open. Can you get the I've lost for a minute our slideshow. Have you come out of the slideshow, Larissa?
Hi, Judge. Yes, I was going to share the documents.
Okay, can you? Is that possible?
Yes.
All right.
So let me
great.
share it now.
Yeah, excellent. So there you go. So this is the Form 9 from Trinidad and Tobago. It's called a listing questionnaire. And the warning is something that I just want us to pay attention to. It says this is an important document. The information is required by the court to list your case accurately. Now, this is a questionnaire that is used for the purposes of listing a matter, but you don't have, a questionnaire is not limited to a listing questionnaire. It says inaccurate information may lead to a waste of court time and delays. Failure to return the form to the court within X days or to complete it fully will lead to a hearing, and you may have to pay costs. And then as you go along, you see a list of questions. Has ADR been tried? Are you ready for trial? Do you intend to call witnesses? And so on and so on and so on. Yes, no. Look at the very important question there. How many witnesses do you intend to call? What is your present estimate for trial length? So what I hope you can get a sense of by just perusing this document is how these kinds of questions in a questionnaire can help you gather information that is relevant. Now, for example, look at question 14. Names, addresses, and telephone numbers of attorneys and so on. You can even ask for email addresses. That way, you can gather the information to deal with the case effectively. It has to be dated and signed. So that's just an example. Let's return to the presentation. The point I'm trying to make here by using that is to show you in a very practical way an example of a questionnaire as we return to the slideshow. And there you go. So what do the questions ask about? Things like disclosure, inspection, witness statements, witnesses, expert reports, ADR, are you ready for trial, lengths of trial, contact information, and of course you can ask about costs. So the usefulness of questionnaires should become apparent, and we hope that at an institutional level they'll be considered. But as I've said a moment ago, even if not so, you certainly can use questionnaires on an individual basis and on a case-by-case basis.
Judge, just letting you know that we're at the halfway mark.
Okay, great. Thank you very much, Larissa. So as we move along, and to summarize what I was saying about questionnaires, well, we recommend that you use it prior to the case management conference. Why? Because we think that the earliest opportunity to gather relevant information really makes these rules work. And so, as I've said in the last few minutes, when you do this, there's assistance rendered to court parties and attorneys to fully prepare. Notice, questionnaires help parties and attorneys prepare. So this is not just about the judge and the court. Again, as I've said earlier, knowledge is power. And an interesting aspect, especially since we've gone through the COVID pandemic, is gathering information can help us decide what kind of hearing should be held. Should it be a paper hearing? Should it be a virtual hearing? Should it be an in-person hearing? All of this can be relevant information we can ask questions about. And of course, as I said earlier, we can use questionnaires to try and explore settlement and facilitate case and case flow, narrowing and identification, narrowing of issues, what is admitted, what is disputed, documents, etc., etc. So we therefore recommend the use of questionnaires. I'm going to shift gears a little bit. And of course, if you have any questions about questionnaires, we'll deal with them later on. Second thing that I want to share some thoughts with on is this question of parties being present. 27.4 says, this is one of our rules, attendance at case management conference or pretrial review. The general rule is the party, others, must attend. See the emphasis? Both case management conferences and pretrial reviews. So this is the imperative. Why is that important? We're going to come share some stories about that in a moment. But the point is the rules require this, and attorneys and judges must insist on it. This is a part of the rules that too often in the past we have said, oh, well, parties don't have to come, their representatives are here, the judge, the attorneys are here, and that's good enough. No, these rules say parties must be present. Of course, you do have a power at 27.43 to dispense with attendance. But remember, you have to, as a court, to say it's not necessary. Otherwise, a party must be present. Let's move along. Why? Well, remember the duties of parties. Parties must help further the overriding objective. How are they going to do that if they're not present? Parties are required to verify, certify truth of facts, documents, information, and there are consequences for failing to do this. I've listed there some of the rules where this applies, both from your statement of case to your claim form, to defenses, to appearances, witness statements. In all of these things, parties now have a role in proceedings where they are certifying as truthful facts, documents, and so on. Their presence in court is linked to the duties and roles they now have to play from inception. And of course, we did this on the last occasion that we met, disclosure of documents and information and inspection and the consequences of a failure to do so. All of these are duties on parties, and therefore when parties are present, courts can to call upon parties, point parties to what they have put into documents, when they are trying to encourage settlement, talk about costs, narrow issues, etc. Moving along. Whose case is it? We have historically behaved as if it's a lawyer's case. It's not. The case is always and will always be the litigant's case. Who decides what in a case? And at what costs? Well, I'm going to ask Sir Dennis and President Saunders to just share from their experiences of dealing with the CPR, some examples of why parties being present made a difference. Sir Dennis or President Saunders?
Yeah, Chief, you want to go first? So Dennis? Okay, I will go. Well, I have had the experience where at a case management conference in a running down action, when you went through the pleadings, statements of case on either side, it was apparent that the defense really was put in to prolong the matter because there really wasn't any serious defense. And the issue really was a question of damages. How much damages should the claimant receive? And the party wasn't present, but I required the defendant to get the relevant insurance company on the phone in order for us to see whether we could arrive at there and then at a figure which would effectively obviate the need for a trial on damages. And counsel was able to get the insurance company on the phone, and we were able to have the matter settled right there and then, with an offer being made, being accepted by the other side. So that it demonstrated to me the importance, because one of the things that the rule says is that the general rule is that the party or a person who is in a position to represent the interests of the party. And you would find very often in cases where a defendant has to be sued in order for a judgment to be given against that defendant so that the insurance could be made liable in running our actions, that often the more important person that you want is the insurance company being present in the proceedings, being present at the case management conference, or being capable of being reached as and when the court requires the lawyer representing the defendant to reach them. So that was the example I wanted to give.
Yeah, thank you very much for that, President. And of course, what the example shows is that, and we know this from experience, often we have to adjourn a matter because a lawyer will say to the court, well, yes, we can think about that, but I need to get instructions. Instructions from whom? And that's why, as the President explained, it's instruct from the litigant. But in, for example, running down cases where we know these are subrogation claims, and the person who's making the decision is really the insurance company. So a person who can make a decision, it will reduce adjournments, facilitate decision making, etc. I mean, I don't know if Sir Dennis is back online with us right now, but an easy example, one of many that I had, was where there was a land dispute, and at the case management conference, I asked about, well, where is this land? And the parties were present, and then I asked, well, did we do surveys? I had prepared it, and I'm going to come to say some of that in a moment. I prepared the case very carefully before, and I knew what the answers were to the questions I was asking, but I was asking them in open court of the parties. It turned out that the land was 1 foot wide and ran the boundary of the parties, which I think may have been 150 or 60 feet or something like that. So the question I asked was, well, what is the value of this land? What kind of land is it? It turned out to be agricultural land. And so this piece of land, which was 1 foot wide and a few 100 feet long, really had no value. Then the second question I asked in court was, to the parties, what costs, how much money are you paying your lawyer to come to court and do this case? And I said, if you don't know, find out. I literally rose, gave them 5 minutes and came back. And when they came back, I said, have you all thought about this? Is there any chance of settling the case? And one of the parties stood up in court and said, can I speak? I said, of course you can speak. You have a right to be here. What do you want to say? Judge, I don't want to fight this case. This is not worth this. I said, no problem. Gentlemen, there were 2 male attorneys, have a conversation. And basically the case was settled. But it could have been settled because the parties were present. But I'll tell you what is key. What was key for me in that case, I had prepared the case very thoroughly and very carefully, and came into court knowing the parties were there with certain questions to ask, sort of anticipating that this could play out in this way. So Dennis, I see you're online with us now.
Yes.
If I may, Judge, just about 4 minutes left.
Okay, good. Yeah. So Dennis, a short story if you have one.
Yes, but you see, I'm telling a story because it happened last night. It started last night. And it's relevant that the person who came to see me was a clergyman, a senior, a popular clergyman, who was the head of a folk research center, which had been insured and had been insured for over a 10-year period, and was burnt down. And when they went to claim for the insurance, they were told that the insurance had not been renewed for the year during which the fire occurred. And they took proceedings against their broker. Now, as the proceedings developed, it turned out that for the insurance period of 2016 to 2017, they had not repaid the broker the full premium. So there was a fairly substantial balance due of about $3,000. And the broker decided not to renew the contract, not to renew the insurance, unless they cleared the arrears for the previous year. And the fire occurred before that happened.
Mm.
So basically, although it reached the stage of going to case management conference, there was no real defense.
Yeah.
Now, it so happened, however, that the owner of the insurance company was a parishioner of the priest who was the head of the folk research company. And he made an offer. The insured value was about $1.8 million. The value probably one. And he made an offer of $140,000 as an ex-gratia payment. And the lawyer advised him to accept the offer. But he didn't want to accept the offer, so he asked for time and came to see me to ask me if I agreed with the proposition. So when I looked at the matter, it was quite clear that he had no defense. And I told him, I said, you know, you have to realize that the insurance company had a good heart. He made an offer of a fairly substantial amount of money when he didn't have any obligation to do that, which means that he wanted to help you. So what you really needed was $2 million. Why don't you ask the broker whether he would agree to use that $180,000 as seed money to launch a fundraising program to get to the $2 million. And this morning, after the case management, he called me after the case management conference to tell me the broker agreed.
Mhm.
So sometimes
and I suppose that's the kind of dynamic situation that having the parties present and engaged can engender, and you can have this position in a matter that is just and fair to all parties. Yeah. Thank you very much for that, Sir Dennis. I think we're running a little tight on time. I think I can squeeze 5 minutes off and finish this off. So, Larissa, let's move along. Yeah, so very quickly then, timely decision making. You know, the CPR 1.22 says that you must secure the most expeditious and least expensive determination of a matter on the merits. So there's clearly a requirement for timeliness in decision making. What I want to just share with you very, very quickly, Larissa, as we move along, is to consider using oral judgments. To use oral judgments during all pretrial events and case management and interlocutory hearings. Give your reasons, give your decisions, and give reasons. You must give reasons, but you can give very short, very concise, and very expeditious reasons. Give them immediately. That is a goal of this CPR. How can we do that? We can do that if we, by using something called an issue-driven approach, which basically looks at an issue, relevant law, facts, analysis, and outcome, and does so with clarity, conciseness, and coherence. I recommend 2 books, a book by Berry, Writing Reasons, a Handbook for Judges, and a book by James Raymond, Writing for the Court. I'm going to share with you very quickly a template that shows how this can be done, which is on the other slide. And this is a very simple issue-driven template. You can use it for written decisions, but also for giving oral judgments. An introduction, for example, there are 2 issues in a case. Issue 1, what is the issue in this case? Whether or not relief from sanctions can be granted. What's the relevant law? Stated in less than a paragraph. What is the evidence? only state the relevant evidence and give your outcome. In 4 paragraphs, issue 1 can be determined, issue 2, etc. And then a summary with orders, directions, and costs. The point is, and I'm just using this as a suggestion, nothing is formulaic or prescriptive, but to say that if you take a simple issue-driven template, where you have an introduction and you deal with issues one by one in the format that Barry and James Raymond speak about, and that we teach actually when we teach judgment writing, it can be very effective for determining interlocutory matters in particular and facilitating timely decision making, and so advancing the flow of a case. Because too often when we look at the record of files, we see long periods where you have an interlocutory hearing before the matter resumes because it's awaiting a decision. That should never be the case, or rarely be the case. Checklists. We recommend checklists for judges. Checklists are basically a list of things that you need to get done at a case management conference and a pre-trial review. Checklists are an aid. They can be developed institutionally or individually. They're for the benefit of a judge. We recommend institutional use of checklists. They serve as both prompts and checks. Prompts as to what you should do when you are in a case management conference or when you are in a pre-trial review. And checks, have you done it? Has what is required to be done? There's a little reference to reading. You already have an electronic copy of the role of the CPIR judge. At pages 23 to 29, you can read and get a little bit more information. Marissa? And here on this slide, which you will look at your convenience, I've identified 6 reasons or suggestions of what you should use checklists for. And you see the repetition. Use checklists to identify, simplify, prioritize issues. So what are the issues in the case? Can I simplify them? Can I prioritize them? Talking about disclosure, make sure you've done your disclosure. Make sure you've explored your settlement. Make sure you've considered amendments, witness statements, witness summaries, etc., etc. Are there any preliminary issues or ancillary issues? What about interlocutory or interim applications? Or this should be on your checklist. And as you go through a matter, you're asking these questions. And then at the end of a CMC, you're considering, have they been done? Are they necessary? And as I come to the end of this little part of our presentation, I've given you some 6 areas where the checklists can be used. And these are things that you can develop for yourself, or you can develop institutionally. Cursor. And these are 5 more. And I'm going to, if there are any questions on the use of questionnaires, the use of checklists, or the question of issue of timely decision making, we'll pick them up at the end. President Saunders, over to you.
Yeah. Okay, thank you very much. All right, so these are the objectives of my session. You'd find that I'm going to sort of re-emphasize a lot of what was said before. As you know, the old litigation culture was characterized by delay and a lawyer-driven approach. The essence of the new culture that these rules seek to promote is captured in the parts dealing with the overriding objective and the proactive management of cases in keeping with that overriding objective. Parts 1 and then 25 through 27. While the old litigation culture was characterized by a court that reacted to the filings and initiatives of the parties, as I said, these new rules place a high premium on the court taking proactive measures to ensure that litigation proceeds in a court-driven manner with considerable stress on event and trial date certainty. So the rules not only invest the court with the ability to exercise its powers on an application, a lawyer, litigant can apply for this or for that, but the court is also encouraged to exercise its vast powers on its own initiative at CPR 26.21. Although, of course, as Dennis pointed out, if the court proposes to make an order of its own initiative, it must give any party likely to be affected a reasonable opportunity to make representations. Now, certain dates and timelines are regarded as sacrosanct. The rules take a hard line on keeping the dates for matters such as the date for a case management conference, obeying the time within which, or complying with the requirement for a party to do something where a rule or a court order specifies the consequences of a failure to keep that time or to comply. The date of a pretrial review, or the date for the hearing of the trial, or even of a trial window. Not only are those dates sacrosanct, but Part 27.82 goes further and indicates that the parties are not permitted to do anything that would make it necessary to vary any of those dates. And the following rule, Part 27.83, states that a party seeking to vary any other date without the agreement of the other parties must apply to the court, so that if there is a date which, if you don't comply with it, there is no sanction that the rules specify, then you can go to the court if you wish to vary that date without the agreement of the other side and apply to the court for a variation of that date. And the general rule is that you can do so before the date actually arrives. I want to say a little bit about the sanctions regime contained in the rules. Judge Greenslade, he was the consultant who worked with both the Trinidad and Tobago Judiciary and the Eastern Caribbean Supreme Court to develop our respective rules in the late 90s. He was actually a member of the Wolf Commission. He compared an effective sanctions regime to an electric fence whose ostensible purpose is not to kill the animals in the enclosure, but to ensure their compliance. So the sanctions regime is really intended to keep you in the right lanes. But of course, you know, human beings as we are, it's sometimes necessary to administer the shock in order to keep you in the right lane. And sometimes it might also be necessary because you persist in going outside the right lanes to take fairly punitive measures if the non-compliance actually requires that kind of treatment. So the rules are therefore underpinned by the availability of an effective deployment of appropriate sanctions designed to require litigants and lawyers to obey the court orders, to observe the rules, comply with timetables, and to seek variation only where compliance is not practical. Applicable sanctions, well, the rules have embedded in them particular sanctions for particular instances of non-compliance. But in addition, there are three main types of discretionary sanctions that the court is empowered to do. And these relate to costs, and later we'll have a session where we talk about costs. Striking out of a statement of case, and the making of unless orders. And so Dennis in his presentation referred to the issue of striking out and also of unless orders. And because these areas are so important, I would also dwell on them as well. So what are the underlying principles and values relating to the sanctions regime? What I try to do is to distill some of these principles and values. Generally speaking, the rules go out of their way to render sanctions appropriate and proportionate to the offense or to the non-compliance. And that is all in keeping with the overriding objective. And in this regard, bear in mind what I stated earlier about the rules taking a hard line on keeping the dates for case management conference, for a party to do something where a rule or court order specifies the consequences of failure to comply, for the date of a pretrial review, and for the trial date or for the trial period. It's a grievous offense to fail to keep any of those dates. And the sanction for committing that grievous offense reflects the gravity of the non-compliance. Secondly, in order to render the sanctions regime more effective, more efficient, the rules are written so that sanctions for grievous non-compliance, they take effect automatically, unless one applies for and obtains from the court relief from the sanction. Thirdly, this is related to the previous value. The rules place the onus on the party at fault to seek relief from the court. There is no onus placed on the innocent party to apply to the court to seek a sanction against the offending party. Often the innocent party can sit back and see whether and how the offending party can wriggle out of the consequences of their non-compliance. In the old dispensation, typically the innocent party would have had to go to court to make an application and to say to the court, aha, the other party has not complied with this or with that. I'm asking you to do something. No. These rules are often written in a way where the offending party is the one who has to do something, if they can, in order to be relieved from the sanction which the rules themselves impose on them for their non-compliance. Fourthly, the rules actually prohibit counsel from circumventing a sanction automatically imposed by simply agreeing among themselves to waive the non-compliance. In the old dispensation, counsel can agree among themselves to extend time, to adjourn a case, to consensually agree on a course of action and simply ask the court to put its imprimatur on that agreement. These rules have eliminated that possibility in those instances where the sanction is automatically imposed. And again, this is in keeping with the ethic of court-driven and not lawyer-driven litigation. Notice Rule 26.73 that says, if a rule, practice, direction, or order requires a party to do something by a specified date and specifies the consequences of failure to comply, the time for doing the act in question may not be extended by agreement between the parties. Fifthly, the rules often themselves prescribe exactly what is the consequence of the non-compliance. So that Rule 32.16, for example, which deals with experts' reports, that is a rule that says a party who fails to comply with the direction to disclose an expert witness's report may not use the report at the trial or call the expert witness unless the court gives permission. So the rule itself has embedded in it the sanction for its violation. You fail to disclose your expert witness's report? Well, simple. You simply can't call that witness. And it goes on to say that you can't turn up at the trial with the expert and expect the court to receive the expert's evidence, because the rule says the court may not give permission at the trial unless the party asking for permission can show that it was not reasonably practicable to have applied for relief at an earlier stage. So, and this is one of the things that you would find in the rules, that you simply can't turn up on the day of the trial and expect to get dispensation of whatever non-compliances you had engaged in the period leading up to the trial. It goes on. Where no express sanction for non-compliance is imposed by the relevant rule, because there are some rules that require you to do certain things and which do not include a sanction for non-compliance. There are some rules like that. Then the rules, if you are addressing a situation where such a rule is an issue, the rules entitle a party in default to apply for the court to put matters right, in which case the court can and should make an unless order. You haven't done what you're supposed to do. Okay, it's not a mortal sin because there was no sanction imposed by the rule, but the court is likely to allow you to come into compliance, but then the court is encouraged to juxtapose that permission with an unless order and to indicate to you that, fine, but unless you file the document by such and such a date, or if you don't file it by such and such a date, then your statement of case will be struck out or something like that. Part 26.7 is the rule that captures what was described in the previous slide. And so Dennis went through this, but it is useful again to do so. 26.7.1, I'll do it quickly. If the court makes an order or gives directions, the court must, whenever practicable, also specify the consequences of failure to comply. Again, the rules seek to have the court drive the proceedings. So if the court makes an order that the witnesses are to give their evidence by witness statement, the witness statement should stand as evidence in chief. The court should go on to say, and if you don't produce a witness statement, if you don't exchange a witness statement, then you're not allowed to produce that witness at the trial. 26.72, if a party has failed to comply with any of the rules or a direction or an order, any express sanction for non-compliance imposed by the rule or by the direction or the order, it has effect unless the party in default applies for and obtains relief from the sanction. So that once you know you have flouted, wittingly or unwittingly, a rule that has embedded in it a sanction, then you have to apply for relief from the sanction. If a rule, practice, direction, or order requires a party to do something by a specified date and specifies the consequences of failure to comply, the time cannot be extended by agreement. We spoke about that earlier. If a party has failed to comply with any of the rules where no express sanction for non-compliance is imposed, then you can make an application under Part 26.9 to have the court rectify things. If a rule, practice, direction, or order requires a party to do something by a specified date and does not specify the consequences of failure to comply, then the time for doing it may be extended by agreement in writing between the parties, provided that the extension does not affect the date of any hearing or the trial. Again, those are the very sacrosanct dates that the rules provide. So although, yes?
Just letting you know we're at the halfway point.
Okay, good. So that although you are in a situation where you can get agreement on the by the other side to extend the date, you can't get agreement to do so if the extension will affect the date of a hearing or of the trial. Part 26.9, that's just the rule that deals with the making things right, where the court is entitled to allow you to apply to rectify matters if you are in a situation where your non-compliance does not have an automatic sanction that is imposed. So you could go on to the other slide, striking out. The most serious sanction the court can make is to strike out a party's pleadings or a party's statement of case. And the rules entitle the court to do so if it appears to the court that there has been a failure to comply with a rule, order, or direction given by the court, or if the statement of case or the part to be struck out doesn't disclose any reasonable ground for bringing or defending an action or a claim or a defense. And in this regard, I could cite a case from the BVI, case in which I was involved. The case is the Bank of Bermuda versus Pentium, civil appeal number 14 of 2003. It's really a case of summary judgment, but the same principle applies here. And the facts were that Pentium was a customer of the bank, Bank of Bermuda versus Pentium. The bank would sometimes act on faxed instructions from Pentium. But those instructions had to be signed by 3 persons, including a certain Mr. Gibson. So the bank received several faxed instructions to pay out large sums of money from Pentium's accounts to a third party. And the bank just paid out the monies. Well, it turned out that those instructions were fraudulent. Pentium actually, one of their employees, forged Mr. Gibson's signature. And so Pentium sued the bank and they applied for summary judgment. Well, the bank's defense, Pentium, first of all, adduced very compelling evidence establishing that the instructions were a forgery, that one of their staff members had forged Mr. Gibson's signature, and that it was inappropriate to, Pentium said in their defense that, well, look, we put you to strict proof that this was a forgery. We have no knowledge that it is a forgery. There ought not to be summary judgment where there are allegations of fraud and dishonesty being advanced. We put you to strict proof to establish the fraud, and so on and so forth. And the trial judge, Justice Rawlins at the time, later became Chief Justice of the Eastern Caribbean, rightly took the view that you have not really put forward anything that shows you have a realistic chance of defending this claim. And we agreed in the Court of Appeal. And we said that a judge should not allow a matter to proceed to trial where the defendant has produced nothing to persuade the court that there is a realistic prospect that the defendant will succeed in defeating the claim brought by the claimant. In response to an application for summary judgment, a defendant is not entitled, without more, merely to say that, well, this case should continue. In the course of time, something might turn up that would render the claimant's case untenable. To proceed in that vein is to invite speculation and doesn't demonstrate a real prospect of successfully defending a claim. In other words, it's no longer enough, and this is something that you must take to heart. It is no longer enough for a defendant simply to say, I put you to strict proof. I have no knowledge of that. The defendant does not admit such and such. No, a defendant must say, your allegation is incorrect because of A, B, C, or D. There is hardly a need for a trial if all a defendant is stating in their statement of, in their defense, in the statement of case, is that you, the claimant, must prove your allegations at trial. You must put up in your defense your positive defense to the claim in order to demonstrate to the court that you have a real prospect of successfully defending the claim. A statement of case or part of it may also be struck out if it is frivolous, vexatious, scandalous, an abuse of the process of the court, or if it is prolix and doesn't comply with the requirements of parts 8 or 10. Those are the commencement proceedings, the rules that deal with the commencement of proceedings and that deal with defense. Unless orders. In lieu of striking out a statement of case, as I said earlier, the court may and is encouraged to make an unless order. That is an order that the statement of case of a party will be struck out if the party doesn't comply with the unless order by a specified date. Next slide. And there is a rule, there's a part that deals with relief from sanctions. A party can seek relief from sanctions through the application of part 26.8. You have to apply in writing. You have to provide evidence. Why did you fail to comply? The court will consider all the circumstances of the case so as to enable it to deal justly with the application. The overriding objective is baked in as well because the court will consider the need for litigation to be conducted efficiently and at proportionate cost, and also the need to enforce compliance with the rules. I want to say something now about the role of the Court of Appeal. I think we touched on it at a previous session. There are going to be a lot of litigants that will be upset if and when the statement of case is struck out or an order is made by the judge that either fails to relieve you from sanctions or some other procedural order is made and you feel hard done by. The Court of Appeal should be slow to interfere with the trial judge's discretion when the judge operates these rules. Invariably, the trial judge would know the case better than the Court of Appeal. And the trial judge must be allowed some flexibility, a margin of appreciation, a generous margin to exercise their discretion in determining how to grant whether relief from sanction or whatever procedural issue, how to decide a procedural issue that comes before the court. It is only where the judge goes outside the rules or misapplies the principle that the Court of Appeal should upset the decision of the judge.
President, if I may, just about a little less
Yeah.
than 4 minutes left.
Good, I'm almost done. I think this is the last slide, if I'm not mistaken. An effective electronic case management system is an indispensable asset in the operationalizing of the rules. Such a system renders a thing of the past the question of a lost file. You have an electronic case management system. The files are at your fingertips. In seconds, you can find any file or any document in any file. A proper case management system, an electronic case management system, also allows multiple judicial officers and attorneys to access the same file in seconds. It can give the court and attorneys alike prompts. It can warn you as an attorney. In a week's time, the date by which you should have entered your defense would have expired. It can prompt you to do what you're supposed to do so that you don't fall into non-compliance. It could allow you and the courts, both Court of Appeal as well as the trial court, to calendar matters in an efficient manner so that you can synchronize courtroom availability. One of the things that should be no longer tolerated is a lawyer standing before a court and saying, well, I'm sorry, my lord, but I cannot proceed with the matter today because in another 15 minutes, I have to appear before the Court of Appeal, and that court takes precedence. Well, every court takes precedence. And there ought to be no excuse for a lawyer double booking a calendar or for finding oneself in a position where you're before two courts at the same time. It is your responsibility, if you have taken every possible precaution to prevent that, and you see it looming before you, to brief somebody else. Because as we keep stressing, the rules take a very dim view of an adjournment of a hearing date. A proper electronic case management system is critical to aiding in the avoidance of these kinds of issues. And I think that's it for me.
President, maybe before you move off of that, maybe you can share that, you know, that theory is in fact in operation in the region, isn't it? Where
of course, yes, yes, absolutely. And a trial judge, and I say this with all due respect to the members of the Court of Appeal who are here, ought not to feel intimidated if a lawyer stands before you and says, well, I'm sorry, I am before the Court of Appeal, and that court takes precedence to your court. We can't operate like that anymore. As I said, every court has to be respected on its own merits. And therefore, the onus is on the litigants and the lawyers to ensure that they keep the dates which have been calendared. So, yes, and even at the magistrates' courts, every court should be regarded as having a minimum level of respect. And it is certainly not encouraged. It is certainly not considered to be something that will be condoned for counsel to seek an adjournment because you are calendared in another court at a particular time.
Thank you very much, President. So that brings us sort of to the end of what we want to share with you on these three, on this, the question of case and case flow management in the three areas that we each have dealt with. But what your feedback asked for was some more time for questions, for discussion, and that time is now. So if there are questions in the chat, I'm not seeing them actually. I was looking in the chat and I didn't see anything.
But I haven't
There was
seen
one question
anything.
with a citation
either.
that was answered. But if anybody wants to raise their hand, ask a question or query, make a comment, please, let's spend some time doing that.
Can I make a comment, Peter?
Certainly.
It's to emphasize the last point made by President Saunders, and I want to do it in two ways. One is might seem to be a bit of a joke, but a true story. Many years ago, I had been in Singapore, and I was discussing with the Chief Justice what techniques he would use to deal with a lawyer who appeared before him and said he had to request an adjournment because he had to appear before another court at the same time. And he said, well, I don't know. I said, but you've been given lectures about this type of thing. How do you mean you don't know how you'd respond if that occurred? He says, well, it would never occur. And if perchance it did occur, the Bar Association would make certain that the lawyer had some jail time. So that's one story. But the real point I wanted to make was that the key way to avoid that type of problem is that care must be taken when calendar dates are being set. So that is the time where you avoid problems of this nature, both at the level of the court and at the level of the attorney. That's the time when care is taken to make certain that there's no double booking of appointments.
Okay, somebody says in the Bahamas, the Court of Appeal does not consult the attorneys when setting matters down. So we often have to say to a lower court that we have to appear before the Court of Appeal. So are we considering changing the way matters are set down? Well, that is something which has to be discussed and reconciled. The point is that the rules do not look kindly on a date having been calendared only for counsel to say that the date should be vacated, so that it would require systems to be put in place in order to ensure that we can get around those possibilities.
And I think that that's where what you were pointing to when you spoke about the need for electronic calendaring, because we're talking about case and case flow management. And so that last slide from the president about electronic calendaring is a systems issue. And Sir Brian has, in introducing these rules, has to also have these conversations with the president of the Court of Appeal and so on. Because it's one court system. No court is running 3 court systems. It's not 3 independent court systems, magistrates courts, high court, court of appeals. One court system that has to now have new degrees of synchronization and so on. If all 3 systems, if you want to call it that way, all 3 courts, all 3 divisions are to work coherently and so. So yeah, before that, there was a comment, the Court of Appeals had stated same comment without input from the attorneys. And so again, that comes back to this question of electronic calendaring. I suppose it's important to note what Sir Dennis shared, that in Singapore, this does not arise because they have a functioning electronic calendar that allows the Court of Appeal, for example, to see or to check, dates and matters, and attorneys to know right away and be able to say what's happening. So
Well, the
Or are
thought
they-
I have is this
yeah.
is that systems can be modified. Our motive is not to create any type of conflict between any sections of the judiciary. But this would probably require, I suppose, the Chief Justice might have to initiate discussions with the Court of Appeal and the President Bar Association, so that systems can be adjusted to accommodate the introduction of the new civil procedure rules, which, as we have been saying all along, it creates a new culture. So ways of behavior, ways of approaching doing things will have to change if the rules are going to be effective. And so in considering the implementation, these are all issues which need to be discussed and addressed to make certain that they fit in with the new culture which has been evolving with these new procedural rules.
One of the areas that we would be happy to hear something about is your thoughts on the rule that says every time a court makes an order or gives a direction, it ought to include consequences. That idea, how does that resonate? I know that we have members of the bar with us as well as judicial officers. Does everyone see how that is important in moving a case along its life cycle? And any concerns about that? Anybody wants to raise anything or ask anything about that? Today we spent a lot of time talking about sanctions and relief from sanctions and consequential orders and so on. No?
I suppose everyone is in a reflective mood.
Yeah.
I was just going to interpose, Peter, that if anyone would wish to say anything as opposed to sending a written note into the chat group, you can use the raise your hand feature, and Mr. Taylor can activate your microphone. So if there is anyone that wishes to have an exchange with the panelists, please feel free to do that.
So we have two questions. One, a comment on what we were speaking about earlier about the conflict of calendaring. Comment is, I do not see an issue. Should the Court of Appeal give a date that conflicts with the Supreme Court date, it would be helpful if counsel brief another counsel in one of the matters. And then there is on what I just raised, what consequences. I am concerned about judges. Sorry, the consequences are fine, except is an allowance made where there are medical reasons for non-compliance. So that if there are medical reasons, and we come to let me just raise the three questions here, and then we'll respond to them. So we'll deal with medical reasons for non-compliance. Second thing, I'm concerned about judges setting costs. That was not discussed today, but maybe judges have to learn about currently hourly rates, etc., to appreciate market rates and set costs appropriately. Well, yeah, we did not speak about costs, so we may put that off to when we do, but it's an important thing to talk about. And then, are you aware of any jurisdictions that use the checklist that you referred to? And if so, can you say which ones? Thank you. So do you want to chat a little bit first about the consequences in terms of medical reasons for non-compliance?
Yeah. Chief, you want to go?
Yes. As I've said before, we always start at the overriding objective. And the overriding objective is to facilitate the just and proportionate resolution of cases. Now, a medical issue is something which, if addressed appropriately, you see, there are two different types of, I think, approaches to that sort of situation. If something is an emergency, then it has to be dealt with in that manner. and the court has to be notified of the particular circumstances with an application to make an appropriate, consider what might be an appropriate resolution of an situation of that nature. But another type of situation might occur. People might know of a medical condition or a medical appointment in advance of the date of the hearing, and do not notify the court in advance. So that might be a factor which the court will take into account. How early is it? How early and under what circumstances is notice given to the court when it asks the court to make an appropriate order to accommodate the problems which the litigant or the litigant's attorney complies with. So I would imagine that part of it has to do with the timing and the nature of the information which the court is given when it's asked to exercise its discretion. Because all of the rules, even the rules dealing with sanctions, all permit relief to be granted in appropriate cases.
But so Dennis, you raise a very important point, which is not limited to cases of medical reasons. That is to say, what does counsel do, and when do they do it when they realize that they cannot make or meet an obligation? When I sat as a high court doing under the CPR regime, it was something I would ask all the time, whatever the reason was, even if it is a double booking, when did you first know? Because the discretion I'm going to exercise will be exercised very differently if you knew about it this morning before you came into court or late last night, compared to if you knew about it last week and did nothing about it until you turned up in my court to tell me I have a double booking. Because if you remember the overriding objective, I think it's 1.2 or 1.3, which says, the parties have a duty to assist the court in furthering the overriding objective, and therefore you have a duty to write as soon as you have information that can interfere with the flow of a case or the management directions that have been given. So I think that the point you make, Sir Dennis, is yes, relevant to medical reasons, but I think it's relevant to all reasons that may interfere with the application of the rules. President, you wanted to say anything on that? There are a few other little things there. Yeah.
No, Richard, the thing with the rules I found is that the rules accommodate reasonableness. And if an issue arises that makes it difficult or impossible for you to comply, as you said, Justice Jamadar, as soon as you recognize that you're in that situation, you do something. But if you wait, if you do nothing, then each day that elapses, your position becomes less and less tenable. So that the rules accommodate circumstances where you may not be able to comply. And it is simply for you, as soon as you recognize that those circumstances have arisen, to take measures that are appropriate and reasonable. That is, you apply for relief from sanctions. And even if the circumstances are such that you can't apply right away because you are too consumed with doing whatever the emergency is, the court would recognize that too, because the court, at the end of the day, would get from you evidence as to what transpired. And as long as you can show that you behaved in a reasonable manner, then you would get relief from the sanction.
Yeah.
The other thought to add to that is that another aspect of the overriding objective is the issue of the recollection that the court has other cases to deal with. So if the court's utilization of time is interfered with at the last minute, it can't substitute any other work on that day. So one of the issues that the person asking for an adjournment has to take into account is doing it early enough so that the court's time and resources can be allocated to another case which needs its time and application. So it all ties back into, as I think as Mr. Saunders said, reasonableness in the management of the various aspects of the overriding objective.
Yeah. So just looking at what's in the chat, there's a little question about the checklists. Where is it used? But there's a little response which says, just by way of commentary, the list in question, well, this is a questionnaire, not on the checklist, but the questionnaire, I said it was not in the rules, and it is, but apparently it is in the current case management rules, Order 31A, Rule 16. And the suggestion is it could easily be migrated into the CPR. So that's good. In terms of checklists, I can tell you that certainly when I was a trial judge in Trinidad, I use a checklist all the time. We develop checklists. In fact, in a little publication, the new role of the CPR judge, that publication contains checklists that are recommended when we teach, certainly when we taught judges in Trinidad and wherever we teach it, that judges develop checklists. I mean, checklists are a very practical tool that judges are asked to develop and use to help remind them of what they need to think about and address in a matter. The other thing is here, are you suggesting that?
Well, I can add this.
Sure, yes, please.
From the time the idea was introduced to me, I have always used checklists. I've used this. I used it when I went to the National Court, and it's very interesting. Many of my judicial colleagues, when they found out that I was using a checklist, even though they've not been using it before, they started using it too. It's a very useful tool, even if it's not required by the rules. I think it's required by the concept of management. I mean, you're asked to actively manage, and the use of techniques is a management tool. I think that's probably where the idea originated. Best management is a good management practice.
Absolutely. And I mean, very early on in the day, we shared that think about each case as a project. And if you have a project, contractors have checklists, what has to be done each day, what has to be done each week, what has to be completed each month. And so that's the practicality of it. That's for sharing, Sir Dennis.
Yeah. And if I may,
yes,
Peter,
so, yeah, sure.
allied with the checklist is the listing questionnaire.
Yes.
Where you elicit information from the parties and focus their minds, focus their attention on things which they need to put in place in order for the litigation to proceed in a smooth manner. And that is something that we currently use. We actually call it checklist, but it's really a kind of a listing questionnaire that we use at the CCJ. Where we ask the parties to tell us their views on this, on cost, whether they have any
But then maybe you can chat a little bit more about that, because the questionnaire is not part of the CPR, even though apparently it is part of the RSC in the Bahamas. But maybe just share a little bit more of how we use it, because we use it very early on in the process. So maybe we use it before CMC hearing. Would you want to just share a little bit about that?
Yeah, that's right. Because, well, we administer it to counsel. It helps us in particular in relation to costs, because it is at that point that you are best able to get agreement, or at least some kind of consensus, if not a dollar figure, some kind of consensus on the approach that the parties can agree on costs. We use it also in relation to the length of submissions, how long the submissions should be. We use it in relation to what else?
In the OJ, we ask about witnesses.
Witnesses. That's where we function almost as a trial court. So it's very useful there, because then you could find out from them who are the witnesses, Where are the witnesses going to be given the evidence from?
How are they going to be given it?
How
do
are they
they
going to be
prefer
given
giving
it?
it?
That's right. So you really get all the information you need ahead of the case management conference to be able to craft the kinds of orders that you would like to see crafted at the CMC well beforehand. And it shortens the length of the CMC and puts you in a better position to manage the case in an effective way.
Yeah. So that today
One of the thoughts.
yeah, sorry, go on, Sir Dennis.
Well, I was just sort of supporting one of the thoughts that that has influenced me a lot, is that once we get into the concept of managing our cases, you see, and you concentrate on the word manage, it pays, I think, to adopt the management practices that the best and most effective businesses utilize. Because if we sort of modernize our management systems in keeping with how the best managers in our communities operate, it will certainly improve the way we do business. And a lot of these tools are just management tools which assist in the efficiency of our operation.
I think that's a good way to sort of round off, sort of what we're talking about today, because it's about active case and case flow management. And the new rules are really underlining this idea of management. So thank you very much for that, Sir Dennis. I think there's one little chat, last thing here that maybe we should address. Are you suggesting that oral judgments be done on the spot or short adjournment be taken to formulate it? So Dennis, you can respond to that. You can start a response.
Well, you see, I'm the wrong person to ask because
or maybe you're the right one.
Well, you see, okay. I think that a large percentage in simple matters, a large percentage of oral judgments can be done on the spot. Although, of course, a short adjournment may not be necessarily be harmful. But the ability to issue a judgment on the spot depends on what happens before you went into court. Because as you saw from the template which Peter produced, aspects of that template can be prepared before you go into court. Before you go into court, you would know what are the issues that have to be decided. And you know the order in which you're going to decide those issues. And there's certain basic aspects of the factual scenario and so on. So you have the framework before you go into court, leaving open the issues that need to be decided after hearing the parties, which you can do if you're well enough prepared. You can do quickly, or, as I said, even a short adjournment to refine what you do might not necessarily be harmful. But I try to prepare. I used to try to prepare myself to give a judgment as soon after the matter has been completed, and that had to do with the quality of preparation before I went into court.
And can I just supplement that, Sir Dennis, by saying that what can help you prepare in terms of your directions, because we are managing this case and we know that some of these things are coming up in advance because of questions we've asked and so on, is ask for short written submissions on the point. What are the authorities? What are your submissions? So before you even have to, if you are having an oral hearing in the first place, because you remember you can have paper dispositions, but if you are going to have an oral hearing, not only will you be able to state the issue, have at least a sense of what the basics of the applicable law and the core facts are, but you would have had the benefit of written submissions, which would distill things for you, so that in a sense, a lot can be done beforehand, but it's how you manage it. All right, maybe I'm just going
Peter, on that same point of written submissions, you mentioned Jim Raymond's teachings on the issue of judgment writing. Now, an interesting thought that he used to advocate was that when you have two submissions, quite often one side is wrong and one side is right. And so you have a template, you have something in your template that will be the basis upon which your judgment is given, already prepared.
Mhm, mhm.
And the other thought he mentioned is that a lot of judgments are lengthened by recitation of the arguments of both parties. And he also suggested that it was not necessary to recite the submissions of the winning party, which will form the basis of the judgment. What was necessary was to address the submissions of the losing party, to explain why they were wrong, so that the losing party, because your judgment would be written to the losing party to provide an adequate explanation rationale for the basis on which the decision was taken. So that's two thoughts.
Yeah, no, and I suppose it opens the door if that is the desire at a later stage to do something on oral judgments and explore this in a little greater depth. We've just had enough time to barely offer a template and to suggest. But in response to the question, absolutely, we think that timely decision making is important, because what has happened is we have seen and discovered that delay in judgments, especially in term and interlocutory application and matters, have resulted in extended periods of delay and in the cancellation of trial dates that were fixed and so on, and that is anathema. We've heard of the sanctions and consequences for counsel and litigants who do not comply with timelines and timeliness. Are there any sanctions for judges, registrars who likewise don't function, deliver decisions in a timely fashion? Do the rules suggest any timelines for the delivery of delivery, maybe of reasons and judgment for the judges? This is a very important point that is being made.
We're going to address that in one of our sessions.
We are.
Yes.
So if you would bear with us, I'm not sure whose question this was from, but this is an incentive or an invitation for you to keep joining us at the other sessions, and we are going to address this. It is very, very important. Yeah, we deal with it under a topic which we will call performance standards. So that's very important. And yes, we are going to do that. I think that may be our final session that we do with this group. So look, just scrolling through what has been sent, I think I've raised everything that was put in the chat at least. It's about 6:50 now, so I think we just have a few more minutes before our time is up. We've spent a longer time chatting. We hope that has been beneficial. I'm going to allow final comments from Sir Dennis, President Saunders, and then Chief Justice. We'll hand it over to you. And for myself, I want to say thank you very much once again for the opportunity. We hope that what we've said has been of value to you, and we hope that but we encourage you to read the rules. One of the comments that Sir Dennis is we meet to prepare for these sessions, and we spend quite a few hours doing that. And one of the comments that Sir Dennis made, I think not when we met on Monday, but it may have been last week, was to say, amongst the three of us, to say, every time I read these rules and every time I reflect on them, after all these years, I continue to grasp new nuances and new insights. And one of the things that he said to us, because we were, well, are we repeating the same thing? And he said, no, we need the repetition is invaluable in the understanding of these rules. So, Sir Dennis, President, any final comments?
Thank you very much. You touched on a few very, very important points because I recall that I had been, somebody had suggested to me that I dealt with these issues so frequently that why do I keep on writing? Why don't I just rehash what I had done before? But I've never done that. Every time I've had to address these issues, I have done it from scratch without trying to. But of course, on this occasion, I did find a slide I'd used in an earlier presentation, the slide of abolishing ambush, but I just took the graphic from that. And as I mentioned, the reading it over and over again always introduces new nuances and new thoughts. So it's a very sobering thought that the learning process is continuous, and it fits in, I think, with the theory that we have been advocating a lot, that excellence is not a state that people or courts reach. It is a process of continuous development, continually trying to be better. And as I have gone through these rules, I realize that each time I go through, my understanding improves. So I would just recommend that even the things that we've done today, the rules that we've given, and you've noticed that every single one of us, as we addressed, we always started everything we did with the overriding objective. So I just advocate those thoughts in closing. Thank you very much.
President, thank you very much.
Yeah, thanks, Peter. I wanted to say a few words taking off from where Chief left off. Because these rules, if they are going to be beneficial, if they're going to make a difference, we have to inculcate a whole new culture. And it's not going to be easy because it would require both the bench, the bar, as well as the court office staff to do things in a new way, in a different way. The rules go out of their way to stipulate those different ways in which litigation should ensue. But it is possible that although the rules do that, we are so accustomed to the old way of doing things that we operate the rules as though we still functioning under the old system. And what happens? Nothing changes. We still have delays. We still pretty much have a case management conference and operate it as though it's the old summons for directions, where it's almost a checklist kind of thing by rote, this granted, that granted. There's no attempt to narrow issues. There's no attempt to front load the case so that you can assess the prospects of getting rid of the case at an early stage. And the three of us, Chief, Justice Jamada, and myself, have had the experience of having to interact with judiciaries that have had the rules for some time, but they have the rules, but not the new culture. And the result has been that very little has changed. I want to urge everybody present here, bench, bar, court office staff, judicial council, to try not to let that happen, because these rules are an excellent aid to making litigation far more effective, efficient, and to building the administration of justice in the Bahamas, which in turn has consequences for your economic development. Investors make a decision to invest or not invest in a country considerably on the basis of the quality and efficiency of the justice system in that country. And so these rules are not just for the sake of lawyers and litigants and judges. They have a resonance for the entire economic and social development of a country. And so we have to spend time in understanding the rules, in appreciating what is different, in encouraging those among the bar, among the judiciary, who are prepared to invest in the new culture and in identifying and assisting in a particular way those who want to get stuck in the old ways. Because you would always have that. Those who wish to get with the program, they see the light, they invest in it, they are prepared to run with it. And you have those who, no, don't want to go, that's carrying me out of my comfort zone. I am too old. I've been a lawyer now 20, 30, 40 years for me to get invested in this new thing. No, sorry. And then they try to retard the thing. We have to find ways of getting around that. I don't know how many of you have ever read a book, Who Stole My Cheese? It's really a book about management, but it's written in very simple terms. And I won't go into it now, but if you come across that book, you must read it. I happened to read it just about the time when we were doing these new rules, and it was so very apt. Is it who ate my cheese or who stole my cheese? It is so very apt.
Just to say, when we introduced the new rules, our Chief Justice at the time ordered copies of that for every single judge in the CPR, and I still have the copy.
There you go.
Know, who ate my cheese? Yeah.
Yes.
So
yes.
maybe Sir Brian, that's something that you should think about. We'll happily do a little talk about who ate my cheese.
Yes.
But I'm just looking at the time. We had 6:58, so I think we have 2 minutes. So Dennis, the last word to you then, and then Sir Brian, I think you want to say something.
No. I was just going to support what President said. I also read Who ate my cheese, and in fact I used it as a teaching tool quite frequently, and I was very happy that President adopted took the opportunity to indicate the importance of an effective justice system to the economic development and social stability of the country, because we are firmly convinced that the efficiently operating judiciary is a critical factor in economic development and social stability, and we hope that these rules contribute to that type of consequence from their proper application as well. So thank you very much.
Yeah, and just to reinforce the value of academics, Tonya from the law school has corrected us all quite diplomatically. Mind you, a question mark, 2 exclamation points for emphasis to say that, well, no, so now now Tonya, you have conflicted us. Is it who stole my cheese or who moved my cheese? And we have different, so we have to have a debate about which book are we talking about. But we don't have the time for that today. Apparently there are 23 different books. But we'll get the right citation for you when next we meet, which is not next week, I believe, but the week after. So Brian, you can close us off. We're just on 7, so I think we're on time still.
Yes, well, thank you very much. You are exactly on time, which is unusual for lawyers. But thank you for another very productive and informative session. And thank you to all of you who have participated by attending this session. I must say, I think that the entire session was very useful, but the last 30 minutes or so, I think is particularly useful because I think we've made the point before that these new rules are not a panacea for the Bahamas, but they are a tool to get us to where we need to be. And I've found the last 30, 40 minutes particularly relevant and helpful in that regard. And I hope that those of you who are here will consider these matters and will enter a dialogue with us, because there are several aspects to these rules. Obviously, we have to learn them. And in some ways, that's the easiest part of it. We have to read them and we have to learn them. What I think is much more difficult is to actually migrate to the new culture of the rules, which will fundamentally change the way in which we conduct litigation. And that involves all of our stakeholders, judges, judicial officers, members of the bar, and all of our other stakeholders. So I thank our panelists for that discussion. I think they bring to this discussion their considerable experience and wisdom in their reactions and involvement with other jurisdictions. And so they speak on this subject with much credibility. And I think there are issues for us to unpack in this process as we move towards the adoption of the rules. So Sir Dennis, President Saunders, Justice Jamadar, thank you very much again for your unique, entertaining, and engaging style of going through what otherwise is a boring process of reading rules. You do bring the words off the page to real life, and you share your experiences, and I think it's very helpful. So thank you very much. I just want to remind all of you, the next session that we have is the 6th of April. So please mark that in your diary, in your calendar, the 6th of April, same time from 4:30 until 7 p.m. And then the session after that is scheduled for the 13th of April. So those are our next two sessions. Our CAJO colleagues will be taking the session on the 13th of April, and we'll have local presenters on the 6th of April. I also take this opportunity to remind you that all of the sessions and the slides are on our website. So you can go there at your leisure. You can share it with other lawyers in your law firms. I know that a number of lawyers have told me they're using the recorded sessions for in-house webinars and seminars, and it's all been working very well. So I'd encourage you to do that. If you go to our website, in the right-hand corner of the home page, there is a label that says Civil Procedure Rules. You simply click on that label, and that'll take you straight to all of the recordings, all of the slides, and all of the schedule itself for the CPR training. So please use that resource, and hopefully it will help you. I think the only thing that is left for me to wish you all a good evening. I would like to thank the principal of the law school for allowing us to use her platform. So thank you, Tanya, for that. And last point, there was discussion today about the questionnaire, and I think this raises a point which I just wish to share with you as we leave. I don't want you to think that the working group forgot about the current provisions relating to the questionnaire. We didn't forget about it at all. It was debated actually quite extensively as to whether we should include the requirement for the questionnaire in the new rules. It was the view at that time, largely because it has not worked under the RSC. And having listened to our presenters today, and having reconsidered the matter somewhat over the last few weeks, we probably should revisit it, because the reason why it wasn't included, because it did not work. I'm sure all of you who practice in the courts know that it's actually fallen into disuse. Very seldom do we have these questionnaires which are completed. And so the members of the working group thought, let's be realistic. But maybe that's not a good reason to exclude it. Maybe the better approach is to include it and make it work. as opposed to excluding it because it hasn't worked. So I think that's an issue which we will revisit and see whether or not we should put it back in. And if we put it back in, we will have to actually enforce it and implement it. And that leads me to the final point. I do invite you, as you yourself read these rules, engage, discuss it with your colleagues, to send your views, share your thoughts about these matters with me. My email address is on the website. So you can send me emails, you can send emails to the registrar. We have had a number of issues that have arisen over the last 5 or 6 sessions, which will cause the working group to reconsider certain matters. We've talked about pre-action protocols, and that's something which I think the present panelists have addressed in one of their earlier sessions. They are not currently in our rules, but we are thinking about them. Today we talked about the questionnaire. With regard to costs, we talked about prescribed costs, which are not in our rules, but that's on our list now to reconsider. So I want you to understand the process. Your input is very helpful here because I am keeping a list of these issues. And as we work our way to the final draft, we will be reconsidering them and we may well be putting some of these issues into the CPR. So if you think that there are omissions, it's unlikely you're going to come up with something we haven't thought about, because I must say we spent a lot of time and we had, I think, somewhere between 8 and 12 lawyers working on this over a period of many, many months. But nevertheless, we are now revisiting some of these issues. So please share your views, give us your input. When we come to the parts dealing with costs, I think that will attract a lot of attention. But send us an email and communicate your thoughts, and these matters will be reconsidered as we move to the final draft. I saw a question, when will the new rules be implemented? I'll just answer that quickly. We intend to promulgate the new rules on the 16th of May of this year. The implementation date may be on that date or it may be delayed, depending on certain matters and how prepared the office staff is and the registries. But the rules are scheduled to be promulgated on the 16th of May and they will come into force shortly thereafter. So on that note, thank you again, Sir Dennis, thank you, President Saunders, thank you, Justice Jamadar. I wish all of you a very pleasant evening, and please note our next session is the 6th of April. Good night.
Okay, good night.
Thank
Okay.
you.
Bye. Bye,
Bye.
everyone.